Okay, welcome back. We're going to cover lesson 5.2. We're going to be talking about partnerships, and we are in the business law book. The goals of this section are to explain how to form a partnership and describe the legalities involved in the operation and termination of a partnership. All right, here's some of the basics as they relate to partnerships. Partnership basics are: a general partnership is an association of two or more persons to carry on a business for profit as co-owners. So again, two or more people carrying on a business for profit as co-owners. Each of the partners is individually liable for the obligations of the firm. So each one holds liability. Uniform Partnership Act was enacted in every state except Louisiana and defines rights and duties of the partners in relationship to the partnership. As a previous business owner myself, one of the things I am going to tell you is a lot of this stuff is state specific, state orientated. So you got to know kind of how your state does something. So make sure you're aware of, and I know we're in PA, but some of you guys might be in Ohio. Make sure you're aware of how each individual state handles the partnerships, or that, for that matter, sole proprietorships or other corporations. Okay. Types of partners. Got 5 listed here. You got general partners, silent partners, secret partners, nominal partners, dormant partners. So let's take a look at limited partnership. A limited partnership is made up of one or more general partners with full personal liability and one or more limited partners whose liability for partnership obligations extend only to the amount of their investment in the business. So that's limited partnership. To retain their limited liability, limited partners must not participate in general management of the business. So I guess that's a key factor there. You want to make sure you highlight that. Nonetheless, to retain their limited liability, limited partners must participate in general management of the business, must not participate in general management of the business. All right, creationship of a partnership by agreement, by court acknowledgement. Certainly, if you're going to open a business with somebody, making an agreement, a formal agreement, is definitely top on the list. A lot of people who are friends and even family members go into business together, definitely still, even though that's the case, your friends and family, you still want to make sure you dot the I's and cross the T's and get the agreement in place. Operation of a partnership, management of partnerships, profits, losses, and property rights, liability for business operations, fiduciary duty above all, and just real fast, a fiduciary duty is an obligation to act in the best interest of another party. For instance, a corporation's board member has a fiduciary duty to the shareholders. A trustee has a fiduciary duty to its trust beneficiaries, and an attorney has a fiduciary duty to a client. But you don't want to say that real fast three times over. Definitely a tongue twister. But nonetheless, operations of the partnership have to focus on these 4 items: management of business, profit, losses, and property rights, liability for business operations, and fiduciary duty above all. How are partnerships ended? By the intentional act of a partner, by action of law, by court judgment. Winding up. Okay, that is the end of the slide. Like I said, if you have any questions, feel free to email your instructor. Please, by all means, read the chapter. It is filled with information, and we do have a connecting PowerPoint that is related to this video lesson. Okay, thank you. Have a nice day.